You're listening to the Valley Current.
Hi, Bob. I found something really interesting, so thank you for making the time to do this. I found a YouTube video that 303 Creative, which is the case we're talking about tonight, I think it might be useful to play it, and it sets the background up perfectly for our discussion because it sort of says everything about what the 303 creative position is without necessarily getting it to be too legal, because it does show the power of the internet to help sort of frame issues and provide context.
Of course, go ahead.
Yeah, this was first done about 6 months ago, so it was probably after certiorari, well, certainly after certiorari was granted.
When my clients come to 303 Creative, what they can expect is someone who cares and has a passion for their business as well. Each and every one of my projects is a reflection of me.
Lorie works with everyone, including those who identify as LGBT, and her faith influences all aspects of her life, including which messages she expresses and promotes as a graphic designer. She always decides which projects to design based on the message requested, and never based on the person requesting it.
As a Christian artist, I was really excited to step into the wedding industry and use my artistic talents, except there's a Colorado law that prevents me from continuing with my work and forces me to violate my beliefs and speak messages that I don't agree with.
Through her custom designs and her websites, Lorie wants to convey the beauty and the complementarity of marriage between a man and a woman, consistent with what her faith teaches her. But Colorado prohibits this. Colorado is censoring what Lorie wants to say and is trying to force her to express the government's message about marriage. Lorie witnessed Colorado use this same law to harass and punish Masterpiece Cake Shop owner Jack Phillips. After realizing that Colorado was engaged in a pattern and a practice of unconstitutional censorship, Lorie knew she had no choice but to challenge the law to protect her freedom and her art studio.
Every American should have the right to control the content of their own speech.
Regardless of the project, every word Lorie writes, every graphic she designs, and every website she crafts expresses a message. What's chilling about the 10th Circuit's opinion, and why we're so grateful the Supreme Court is reviewing this case, is that the court said Colorado could control Lorie's speech and tell her what to say and when to say it. That means the government can force any paid artist to say just about anything. That's very dangerous, and it violates the Constitution.
It's important that our First Amendment rights for free speech are protected, and I'm thankful that the court's going to hear my case and hopefully protect those rights for myself and all Americans.
Okay.
Yeah, it's interesting. Alliance Defending Freedom is the funder, and Lorie Smith, which is sort of a sole proprietor that runs this little company called 303 Creative LLC. And the part that's sort of interesting is the case was done on stipulated facts, and I'm sure you're going to note how important that is to perhaps the analysis and the outcome. And
yes,
it took the case at a time when there's obviously enough votes. There's 4 very conservative votes. I'm not counting Roberts in that conservative foursome, that 3 of which were appointed through the Trump presidency, even though he lost Colorado. Colorado used to be very much a red state. It's now leaning more blue. I know at times I've heard people talk about it as though it's purple, but it's been mostly Democratic since, I want to say 2004, but perhaps 2004 and earlier, it was mostly Republican. And so it's starting to change. The governor of Colorado is openly gay and is married to another gay man. So it's...
And not only that, he has one of the best popularity ratings in the country.
Right.
I mean, that can happen. In Massachusetts, you've got a Republican governor in this deep blue state, nonetheless popular as hell. So voters do pay attention to who the heck is governing them. They do.
Right. So Colorado has passed a number of laws. This one is a public accommodation law. Think of it as historically restaurants that discriminated against Blacks. These laws eventually got passed and changed both federally and statewide. The idea that if you open a business to the public, you have to not discriminate. And of course, the non-discrimination has extended not only to race, but to just about every protected category, including LGBT. Right?
Religion, sexual orientation, ethnicity. Yes.
Right. So with that,
so there are subtle differences among those things, right? But go ahead.
Right. So Lorie Smith is an individual. We all can probably agree she could never afford the kind of litigation that made its way from the federal district court in Colorado to the 10th Circuit Court of Appeal, which was the court from which Justice Gorsuch came to the Supreme Court. So he's very familiar with that court. And that court upheld the Colorado statute as being one that was a neutral statute that wasn't necessarily violative of First Amendment rights. And this alliance, this ADF, this Alliance for Defending Freedom, spent a fair amount of time and money, including getting this case to the U.S. Supreme Court. And argument occurred, I want to say Monday, which now is available in both transcript and audio form. And both of us listened to and read the transcript and listened to the audio, which went on for like 2.5 hours, and had Miss Wagner, who now we have a face associated with The Voice, presenting the argument. And I wanted to get your reaction, because the one thing I will say, just contextually, we both worked at Davis, Stafford, Kelman, and Fenwick, now Fenwick and West. And the one thing I really remember, Bob, and now you're a professor, Robert Acker, but back then you were a lawyer with me, an associate at the firm. And I remember we were at some annual retreat or some sort of thing where everyone was together as a group. And one of the things that happened in the course of the entire firm meeting, it wasn't that big of a firm, but it was big enough for a group of us to be in a room in a dining hall, I think, as I remember it. And somebody, I think from the Los Angeles office, said something about some aspect of a case we were doing for Iran, the country of Iran. And I remember
I remember that. I thought that was before you joined, because the Iran thing happened in 1979.
No, I remember. I was there. I think it was 1980, or at least this is what I remember. I remember you standing up and saying, "Why the hell are we representing Iran?" And there was total silence. And then one of the partners from LA said, "Because they pay our bill and we're open for business to the public." And it was almost like this view that the firm had that, well, we serve whoever can pay our bill. And we were trying to say, or at least you were trying.
One thing I learned in law school, this point came up, and it's one of the few things I remember from law school. But what I learned is a lawyer is not a bus. You don't have to pick up everybody.
Right. The private practice of law is a practice of choice. You choose your cases, you choose your client, or you should be able to. Sometimes a court can impose on you some pro bono obligation, but even then, it's sort of just suggested and sort of requested. It's not forced as involuntary servitude. But this case does not involve the 13th Amendment. This case involves the First Amendment. And I wanted to get your reaction to what you heard and what you read and how you see what's playing out. And I know you have some views on this. So tell us what you think.
Well, I want to start with the cake case with Jack Phillips, which was briefly touched on. Not because there was a holding in that case, but because it set the stage for what happens next. And what happened in that case was there's a baker, and he makes wedding cakes. And this goes back to 2012.
In Colorado, a gay couple, in Colorado as well.
The case was in Colorado. They were married. There was no gay marriage in Colorado then, but this couple married in Massachusetts. Then they wanted to celebrate back home in Colorado. They went to this baker and they wanted a wedding cake, and he said, I can't make a cake for a gay marriage celebration in derogation of my Christian beliefs. So they took him to the Colorado Human Rights Commission, and then they didn't have, it wasn't on their nickel either at that point. Then the Colorado Human Rights Commission landed on him like a ton of bricks, and they fined him. They required him to go to classes in human rights and putting things in the stream of commerce and non-discrimination, and enjoined him from ever doing it. I mean, they really did a number on him. I guess at that point he was sponsored by the Alliance for Freedom, because he could never have gone through the ensuing 6 years of litigation either.
Right.
Right. So that eventually went to the Supreme Court on the question of whether the state can compel an artist to say or do anything that the artist doesn't want to say or do, such as either sell a cake to a gay couple or to put icing on the cake saying, Jack and Jim, congratulations, blah, blah, you know, can the state do that? And the holding completely punted. The holding was the Human Rights Commission record is so defective that we vacate it without even passing on any of the substantive cases.
Right.
So the whole thing was still up for grabs. Then comes Lorie Smith and her wedding invitation online business.
Website. Right.
Yes. She already does websites. I take it some of them are religious themes, but none of them had to do with weddings. Now she wants to expand into the wedding invitation end of websites, and she's afraid, and probably with some justice, but nothing has happened yet. She's afraid that if she does that, the Colorado Human Rights Commission will land on her the way they landed on Jack Cook.
Right. It's a
so she goes to court.
It's a pre-enforcement case. It's a pre-enforcement.
Yes.
Right.
I don't remember any other pre-enforcement cases going to the Supreme Court.
Never.
Is there a ripeness issue? By the way, for our listeners, a ripeness issue means there has to be an actual case or controversy. You don't usually go to court and say, I'm afraid something bad will happen, so please prevent the bad thing from happening. That's not usual. Does it offend the ripeness doctrine?
Right. It's almost like there should have been at least a notice letter to her or something else, but there wasn't. And so she
hasn't done anything yet. She's
right.
done a mock-up of the website, but she hasn't put it in the stream of commerce yet.
Right. Right. So it's a unique case for the Supreme Court to even consider, and arguably for even the district court to not immediately dismiss, taking the view that, you know, you got to have more skin in the game. You got to go out there and see what the state actually decides to do. And from there, we'll be able to build some sort of factual record, because we don't know. Now, in this case, there were actual stipulations that were negotiated and drafted with the view that I take that the state actually was complicit in the view that they wanted to have their law tested by the courts. And they were okay being complicit with this idea of let's develop a made-up record, made up not as a fake record, but made based on stipulations that we could present to the court that says, if this case were tried, here's what the facts would reveal. And that's what they did. So to me, the state decided not to use the defense of the procedural defense of it's not really ripe. We don't really know what she's going to do. We don't know the precise website she's going to issue. We don't know what the real controversy, the case or controversy really will be yet. We're going to wait for that to happen. So the opposite of the case involving, what is it called? Magnificent Cakes, the cake maker. What is it called?
Something like that, yeah.
Yeah.
Masterpiece cakes, yeah.
Masterpiece made these magnificent wedding cakes and refused to provide that product. to a gay couple that wanted to buy it because the view was he's an artist and he can
So your
choose.
answer to the ripeness question is yes, but you can get around the ripeness doctrine if both parties agree to a state of stipulated facts sufficient to try the case.
Right.
And that's what happened here.
And the part that's so interesting is if you scour through the approximately 100 federal rules of civil procedure, which govern the way in which procedure works in the federal courts, is slightly less than 100 of them. There's no rule specifically that says trial by stipulation. There actually is a rule in the Code of Civil Procedure in California that allows parties to stipulate to a trial record as a way to avoid actual taking of testimony. Essentially, you're stipulating to findings of fact that the court can rely on in presumably issuing its declaratory and perhaps injunctive relief, depending on the remedies that are asked for. There is no such provision, but I assume that what happened here is, given that the state was willing to cooperate with the plaintiff, they developed what must have been stipulated facts for cross motions for summary judgment that the district court ultimately heard and that ultimately made its way up as the record to the 10th Circuit. I mean, I haven't gone back to the district court's decision and looked at what that procedural history is, but I'm sort of presuming they used Rule 56 of the Federal Rules of Civil Procedure on summary judgment to say, well, we could stipulate to facts that way and then use that to say these are the undisputed facts. And those become pretty central to what the quote unquote record is that makes its way up to the 10th Circuit and eventually to the U.S. Supreme Court.
But the facts that they stipulated to were fatal to the state's case. And I want to say why that is next.
Well, wasn't fatal in the 10th Circuit. Arguably in the 10th Circuit, those facts were like, we don't care. It's a neutral law that is really just barring people from discriminating based on status and not on message. I mean, that's essentially where the 10th Circuit came out. It's more about the it's more about the who
the potential buyer is rather than what the potential buyer is buying.
Right. Exactly.
But the problem is this, and I had a hypothesis, and you can discuss the hypothesis. When we go back to about why these facts were stipulated as they were, the rub, well, if we go back to the cake case, okay, it always struck me that the plaintiff, the baker, Jack Phillips, had the practical equities on his side. In other words, he's either going to be forced to do something strongly against his conscience if he loses. If he wins, and the cake buyer has to what? Go across the street and get another cake. Okay? I thought the equities were quite unbalanced. I know, stream of commerce, but even so, I mean, the burden placed on the plaintiff if he loses was far greater than the burden placed on the defendant if they lost. Mm-hmm. Okay? In an attempt, possibly, and here's my speculation, in an attempt to balance the equities, the 10th Circuit held that the plaintiff, here not Jack, but Lorie Smith, that her products were unique artistic expressions. And what that means is the defendant or the gay couple can't go across the street and get another website. There is no other website just like this unique product, and therefore that balancing of equities is short-circuited.
Yeah,
but in the course of getting there, they held that this is unique artistic expression, and if the state wins, since all artistry is unique personal expression, if the state wins, that means the state can mandate every artist, okay? And that's going a little far. And right. I think the Supreme Court is going to fall all over itself to throw up on that. What do you think?
Exactly. No, I think in listening to the oral argument, it was clear that all of the justices were trying to fathom what is it that is so unique about building a website that has, say, a half dozen categories: who the couple is, where they're getting married, the date of the wedding, what activities are expected, what they're
None of that.
Right?
None of that. But there is part of the website that is more personal. And it has to do with our story, how we met, what we mean to each other, and so forth. Okay?
Right.
And that is done in one-on-one individual consultation between Lorie and the prospective buyer.
Right. That tailoring, as it were, because I'm sure even though the images that we saw from the video that we played at the very beginning suggested that she was building these sites in paper and pen and pencil and colored pencil on a page by page kind of basis, laboring over each and every image. The reality we know from the way in which these web businesses work is there are templates, and the templates are almost automated to the point where, yes, there are choices of color, there are choices of typography, there's obviously word choices, but there's a lot of standardization. I'm not going to say it's a robot-based automation.
And I think the plaintiff conceded that if she did all the work and then put a finished product, does Radio Shack still exist? And then put the website on at Radio Shack or wherever, her part now being done. She finished her work. It's now in the stream of commerce. Then the defendant or the buyer buys the product, fills in their name and the date and the place and all that. Then she has no case.
Right.
Plaintiff conceded that. But if that's not so, if a one-off in which there's individuation, then she has a case.
Right.
So do you think she has a case?
She has a case, and the question is there ultimately a line to be drawn around she has to still deliver something without agreeing to violate her conscience on whatever slide or page that she says, I can't write this for you because of my conscience, but you can write it for yourself, effectively, because I'm open for business and I can't discriminate against you based on the fact that you're gays, but I can refuse to do the one page or the one set of text that is against my conscience, because I think marriage is about a man and a woman who get married. And there's all sorts of variations on a theme that the different justices pointed to, which is, well, what about the man and the woman who each are getting divorced because they fell in love, they were married at the time they fell in love and they were at work. And that goes against some religious beliefs where marriage is supposed to be
and that
forever.
was a hypothetical that Amy Barrett, who, by the way, my estimate of her abilities went soaring when I saw that. And she said, what if the couple is heterosexual and they come to you and we're doing our story, and our story is we were both married to other people. Neither of us was happy. We met, we fell in love. So we divorced those people and now we're getting married. And would Lorie Smith do that? And the answer was no.
Right.
In other words, well, I'm not picking on gays. I'm picking on anybody whose marriage does not comport with my view of traditional Christian marriage.
Right. But I want to get back to this idea of, can the line be drawn that you're open for business, you can't discriminate based on status as being gay or lesbian or whatever, LGBTQT, whatever is the full acronym at this point. But you can refuse to do certain pages that you say conflict with your views about marriage and about marriage being one man, one woman, and one marriage. And essentially that page gets left blank with the view that, you know, you can type in your own stuff and get this website launched.
Yeah. I mean, if Lorie Smith agreed to do that and said, I'm not doing this story about how you were married to other people and got divorces, but I'm just going to leave that blank and you can fill it in, then there would be no case. I mean, there'd be no problem. There'd be no litigation.
Right, because there wouldn't be.
But can't she say, no, my product is an integral whole and I don't sell things in that shape? Can't she do that?
Right, and where does the line get drawn on she's discriminating then against a gay couple, as opposed to she's discriminating against this view of marriage that conflicts with her religious and other First Amendment values, right? I mean, that's ultimately where the court's got to disentangle this question of status versus message. And I thought Gorsuch got to this point by the very end in saying, well, is it status, is it message, or is it both? And to some degree, it is both, right?
But yes, there's a certain line of cases in which the conduct and the identity of one of the parties are so closely intertwined that you can't distinguish between them. And apparently there's a case in which a tax was enacted not on Jews per se, but on Jewish religious articles like mezuzahs, okay, and Stars of David, and yeah. And does that fly? And the answer is no. I mean, that's a mere subterfuge. You want to tax Jews? Give me a break. Okay, so there are some cases in which identity and in which content is a stalking horse for identity.
Right, exactly.
But now I remember the question, but is this one of those cases, or is there a difference between identity and content? In other words, do you agree with me that Amy Barrett's hypothetical about the divorced couple getting remarried is a very strong hypo for the plaintiff?
Yeah, it's a very strong statement that the plaintiff is not discriminating based on status. The plaintiff is looking at whether or not there's a conflict in religious beliefs about what marriage represents. It's not different than what you said about representing Iran. When you said it, asserted an objection saying, why are we representing Iran? Iran has taken hostages of American citizens. And we're in kind of a Cold War with Iran. So why are we
not only citizens, but of diplomats? I mean, we were basically at war. I mean, yes.
Right.
And if we had bombed the crap out of them, we would have been totally covered by international law.
Right.
I mean, Iran was in derogation of the law, period.
Right. And you were pointing out we shouldn't do things just for money. And the partner at the time was sort of trying to justify it, as I recall. Hey, we're open for business. We don't want to discriminate. They have a case. We have justice. We have laws. The laws have to get handled, and we're going to represent them. And I remember there being just like a quiet in the room, like, wow, are we just really in the private practice of law for the money? Or do we have a principled view?
Is that a serious question?
Yeah, exactly.
I remember we used to have weekly teas,
right?
And each of the associates would do a presentation at the tea,
right?
And Santa Clara County had passed new guidelines for written briefs, and the guidelines were to the effect of, we're tired of reading all your stuff, so we're limiting you to 15 pages.
That's the law.
It doesn't matter what the case is and or who you are. 15 pages. That's it. And all the partners like stiffened in indignation. You mean we can't spend another $40,000 on the brief to the trial court in San Jose? Give me a break. I remember I'm living in Laos. These people don't know.
Right.
And Laos is a tonal language. So the same morpheme, like jiao, can be pronounced in 3 or 4 different ways. And each different way of pronouncing it has a totally separate meaning, like jiao, 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 3 separate words.
Mm-hmm.
And in that case, the 3 separate words mean the lawyer is chasing the dollar. Okay, that was a joke.
It's the same? It's the same?
The same morpheme can mean different things depending on whether it's pronounced high or low or question falling at the end.
Mm-hmm.
I don't think there are 3 words that mean the lawyer is chasing the dollar, but yes.
Okay, so
the lawyer is chasing the dollar.
They understand.
Let me get back to the issue. So right. If the Supreme Court held, totally persuaded by Amy Barrett, that this shows that the state is trying to regulate the content of artistic expression, not protect protected classes like gay people. And so we rule in favor of the plaintiff. Would you have any problem with that?
No, I mean, I have to say, I think there is risk of unintended consequences. And that was a lot of what the 2.5 hours or so of argument were trying to figure out where to draw the lines. And you get the flavor that the justices are all across the board pretty uncertain about what to do. How do we frame this, or how do we quote unquote cabin this? The wording is often cabin, like put some framework around it so that we don't get the caterer to come in and say, well, I arranged the food to look like a work of art and I don't want to cater.
Or Jack Phillips is going to be a clear winner on that.
Right.
All right. And then the floral arrangement. Well, I picked the flowers with, pink for the girl and blue for the boy, and you can't make me stop, yada, yada. I mean, right? So are they going to have a narrow holding or broad holding? I think you and I are agreed that the plaintiff is going to win. But the question is, win big or win small?
Yeah, I think it's going to be a small win and not as big as the alliance would otherwise want. And I think there's going to be some lines drawn around how customized or how unique is the services that are and the expressive services that are being rendered. I'm sort of hinting at this view of she might well have to deliver a template where there is no expressive content. That seemed to be a lot of the push among the more liberal justices, that look, there's stuff here that is just factual. It has like nothing to do with any sort of statement of religion. And factual
we
stuff
touched on that earlier.
Right. Date, time, place, hotel arrangements.
Well, if that's the ruling, can Lorie Smith say, it's all very, yes, parts of my website are totally generic, parts are not, and the buyers want me to sell the generic stuff and leave the other stuff blank for them to fill in. But I don't work that way, and I'm not going to do that. Can she do that?
I think she can, but she has to do it in sort of a completely non-discriminatory way. It's got to be like if Colorado were to test with, say, a test couple, a gay couple, hey, we want you to do a funeral invitation, which has nothing to do with marriage and nothing to do with man and woman. Our dad or father-in-law died, and we're married, and we want to.
Stay tuned for part 2 of this episode of The Valley Current.